Your Heman, I believe this was it. You had mentioned it. It was one of the gas stations, I think.
Victor Mesa. And probation, this is an application for probation. Hello.
Good morning, Judge.
Good morning. And counsel, you're on this side. This is Criminal Trial Division. Court is calling 2023 CR 8380, State of Texas versus Victor Mesa. I'll walk you through it.
Honor Joe and Nelson for the state judge.
For the defense.
Alma Benavides.
And are you Mr. Mesa?
Yes.
Counsel, have you received all the discovery? Did you review that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mesa, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you, I'm sorry. Next, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears you're proceeding on the indictment as presented.
We are, Judge.
I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Mesa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $500 fine. State recommends community supervision. There's to be $57 restitution for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and 80 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offers States Exhibit 1 with attachments. No objections, Your
All
Honor.
right, you may continue to confer. Thank you. Going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're just asking the court to follow the plea bargain agreement. My client is 49 years old and he is currently employed. He does remodeling and plumbing. He works under a subcontractor and he is working full time. And so we're asking the court to grant his application.
All right. Mr. Mesa, when you're drug tested today, what are the results going to be?
Just marijuana, Your Honor.
All right, no methamphetamine or anything?
No, ma'am.
When's the last time you used meth?
That's just it. I don't use it, ma'am. I don't.
Well,
use
why is there meth in your wallet?
it. I cleaned out my niece's car and I think I put it in there. It's been like,
Who cleans out? Wait a
it's
minute.
because I took it out of the impound yard. She had lost it to the impound yard and I took it out and I was cleaning out the car. And
Okay,
I
let me just
discovered-
tell you why that doesn't ring true to me. I don't know anybody who cleans out somebody's vehicle. I can understand, oh, I'm cleaning out my sister's vehicle. I don't have a sister, but I can understand. Or I'm cleaning out a relative's vehicle. Oh, this is a social security card. Let me put it in my wallet for safekeeping or in my purse.
I understand. Your Honor.
But I don't clean out a vehicle of a relative and I see meth and I'm like, oh, let me put this meth in my wallet for safekeeping. Who does that?
Actually, I put in there to present to my brother-in-law, Your Honor, but that's the truth.
We're going to do a drug test today before I send it to you today. Are you prepared to go today or you need water?
No, ma'am, I can go today.
Okay. All right. We're going to do a UA and then we will come back.
Okay.
All right. Thank you.
Thank you, Judge.
Probation, could you give me a UA?
Have a seat in the audience.
All right. It's Victor Mesa. Oh, I'm just letting them know who it is. And everyone, we're recessing at noon. Anyone who's not ready, you're coming back during the break. All right, Mr. Mesa, if you'll come forward. We're back on the record in 2023. Do you need this for them to do their plea? We're back on the record in 2023, CR 8380, State of Texas versus Victor Mesa. All right, Mr. Mesa, you're positive for something other than marijuana. Why?
I only take Sudafed and Tylenol because of my sinus and because of my pins and my screws in my foot. That's it, ma'am. I don't see how that's possible. And
Yeah.
I can do it every day this week. And y'all, I mean, if I have to stop taking my medication, I'll stop doing that. But
Mhm.
I really do it because of my surgery on my foot.
Mhm.
Well, that's not nothing. Because
All right,
my drug is supposed to be cocaine and-
this is what the court is going to do. The court is going to sentence you to a $500 fine. That will be probated. And you stated you didn't have children, correct?
Ma'am,
Do you have children?
yes, ma'am.
How many?
2,
What are their ages?
26 and 21.
And who do you live with?
My mother,
Why are you living with your mom?
she needs help with the kids. She adopted my niece's kids.
And how old are they?
They're 10 and 5. I mean, 10 and 15.
All right, she doesn't need help with the children if you're using marijuana
Yes, ma'am.
and you're positive for marijuana. When's the last time you used?
2 days ago.
Why are you using drugs and you know you have to come to court?
Ma'am, that's something that I've been doing for a long time, and I was honest before about it. You know, I don't lie about
Well,
it.
I know you've been doing it for a long time because when they pulled you over, they said you were eating it.
I wasn't eating. I don't know how.
Well, they said your teeth were green and you had marijuana leaf in your
I-
mouth.
I had told the officer I just came from my house. I was going back to work. I just ate, but I mean, I'm not gonna
Marijuana,
dispute-
according to
No,
them.
ma'am.
All right, court is going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years. $57 restitution for drug testing. 150 hours of community service restitution. I'm going to require parenting classes. And probation, I'm sorry, but you're going to have to go out to that house and check on the children who are in his mother's care. So it'll be field visits 1 time per month until further notice. Children don't want to be around people who smell of marijuana. It messes with their brains. Doesn't help their brain develop. You understand?
Yes, ma'am.
And don't be bringing marijuana into your mother's home.
Yes, ma'am.
And don't be driving her around with marijuana in a car with the children in the car. because they don't need to be smelling marijuana. It stinks. Field visits 1 time per month. 150 hours community service restitution. I'm going to order parenting classes for him. If he completes that, then the 150 hours will be waived. There's to be regular reporting by Zoom or in person. I'm going to want him with the UA hotline. Test him for levels. Those levels had better start going down. You understand?
Yes, ma'am.
There's going to be 90 sober meetings in 90 days. TAP evaluation, follow TAP recommendations, but I'm sure they're going to recommend intensive outpatient treatment. So let's start with intensive outpatient treatment before inpatient. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Also, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You're going to go off the record. Don't be bringing nonsense to your mom's house, because she's letting you, a grown man, live at her house. Understand?
Yes, ma'am.
All right, good luck.
Thank
Thank
you,
you,
ma'am.
Judge. May we
You're
be
welcome.
excused?
Yes, probation will go over conditions. Why do I have the file on Fernando Espinoza?
Class number 22-39243 is called. You are Department Joseph Chason.
Yes, sir.
Present with your attorney, Mr. Lane, and the state's attorney. Earlier, you pleaded guilty to this indictment in this case, alleging aggravated assault, a second-degree felony. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it?
Defense has and no correction.
We have, and there are no objections or changes.
It's made a part of the record for all purposes. And the defendant just pleaded to paragraph 1, I believe.
That's correct, Judge.
So the agreement here is whatever sentence shall not exceed a cap of 7 years. So no less than 2, nor more than 7 years. The defendant can also be placed on deferred or unadjudicated probation for up to 10 years. And regular probation, I believe, is not an option under this
That's correct.
circumstance, under the allegations. All we're going to start with Mr. Lane. You may go forward, sir.
Your Honor, we're asking the court to defer all proceedings and place Mr. Chason on probation for a term of years, and that he be required to fulfill the conditions of the plan set out in the probation report. It does note that he is a low risk of reoffending. Your Honor, Mr. Chason has been married for 16 years to the victim in this case. They have had altercations in the past. They've led to police being called, charges being dropped on both sides. And it just has turned out to be a toxic relationship. Mr. Chason has, he was actually bonded out by the victim in this case. She was the first one to notify a bail bondsman to try to get him out. He does, with the two children, he has to pay child support. He just got a new job as a carpenter, doing some roofing and remodeling. He cash apps, child support payments as best he can through his sister, who's very helpful. He does have a relationship with his two children. They are legally divorced over in Louisiana. That visitation at this time is supervised. And of course, the court knows if he does violate a condition of probation, it doesn't go to anger management. He could get 180 days as a condition of probation. He could be sentenced to 20 years in prison. I've submitted to the court 17 support letters from his family, his siblings. All of them had stated that he is charitable, that he is a family man, that he is helpful, most importantly to his mother, whose ailments require daily help from Mr. Chason. He is there. He remodeled their house along with another sibling. The letters also indicate that he's very encouraging to his siblings to stay in school, to stay at their job, fight the good fight, and that he had done what he could to give to his siblings what he had. He obviously needs to be away from his children's mother. They, as you've seen in the court's experience, they fight and get back together and fight and get back together. And I submit to you that's what happened here. But other than that, there hasn't been aggression with anybody other than his spouse, is my understanding.
Of all people on the planet to make the exception to that rule, your spouse. So everyone else on the planet, you're going to treat well, but it's your spouse that you feel like needs the living hell of a life. I mean, didn't you pay attention to your vows when you were married? Didn't you? Or were you intoxicated during that time like you were at this event?
Whenever we got married, she wasn't on drugs.
Sir, you were intoxicated. Here's what police woke you up and asked what happened. You were considerably intoxicated and you couldn't even respond. How would you even know what was happening? You're catatonic. Weren't you? You weren't drinking that night? You weren't intoxicated that night? You didn't even wake. Okay. Officers woke you up. What happened? They asked. You appeared to be considerably intoxicated and would not respond. These are police officers who deal with these situations every day. You don't think they can tell somebody's intoxicated or not? Okay, hold on. Let's see. You were on, let's see, probation. Let's see. Violating a protective order in 22. I guess this was involving the same lady. In 04, underage driving under the influence. We started out early, wasn't even an adult, and you were driving intoxicated. Let's see. Aggravated flight from an officer. 1 year hard labor for that in 05. Disturbing the peace by appearing in an intoxicated condition in 16. Pleaded guilty to that. Driving while intoxicated, second. That's a disposition unknown. Disturbing the peace by loud and profane language. That was dismissed. Simple assault, dismissed. Disturbing the peace by time. You keep getting arrested for stuff. And really, convictions are what's important, but there's so much smoke here, it's got to be fire. You're the one with this record. How many times have you been arrested? Can you even guess? Let's see. And the aggravated battery here in 17, domestic violence. Who was the victim in that case? Your wife? Yeah. Yeah. The lady who's so evil that you're saying is so evil, where you're completely innocent. So you pick up 1 year home incarceration, but that was revoked the following year. Let's see, domestic violence with a dangerous weapon, public intimidation. Wow. What a charge there, huh? In 2019, domestic abuse, battery with child present. In 21, the judge issued an order prohibiting you from possessing or purchasing a firearm. Well, we can read between the lines what that was all about. So, you're the innocent one. What else?
Your Honor, he's not an evil or mean person that I see. I mean, we see him when they just like to beat on whoever they can, and the weakest ones is correct. He doesn't seem that way to me.
I'd say he has a consistent pattern. You want to call, you don't need, you can label that evil or not, but there is no crime for being evil. I wish people weren't, but there are crimes for not following the rules of law, which he has been consistent in doing.
They have taken the steps. They have officially divorced. There is a visitation order in effect in Louisiana, which provides for protection of the victim in this case, and even children, if so. And I believe the restrictions in probation here can also provide her the safety and the community. And I don't believe he'll reoffend, Your Honor. He has a very strong family. They've been in constant contact with me, as has he. He's back to work. I think he can do it.
Told the probation office that he drinks daily, but does not have a problem. During the pre-sentence interview, the defendant did not accept responsibility and denied assaulting the victim.
The plea was on October 2nd, Judge.
You know what? I'm trying to pull up an event from October 2nd, and the pad doesn't allow me to do my job.
October 2nd? Yeah.
Mr. Chase's case, they pleaded guilty. All I have is an August Marable on October 2nd. That's all it pulls
We
up.
have to put it back on. It doesn't save it.
Say that again.
It doesn't save it on there. I have to pull it back and have it Tuesday. So we can do it.
I'm going to remind you here, like all cases that we go over we've done this thousands of times. And you signed a document under oath that states, in light of your statement here, that you're not taking responsibility. And here's my favorite one. If it wasn't for my record, I would have gone to trial. That's just pathetic. I did not touch her, but yet under oath, you signed a sworn document that I am mentally competent to enter my plea, which is freely and voluntarily made. I've read the indictment. The attorney has explained it to me. I have committed each and every allegation charged. I am guilty of the offense and any lesser included offenses alleged against me. I swear all of this is true. So help me God. What you pleaded guilty to that we went over was that you intentionally and knowingly and recklessly caused bodily injury to Maggie Chason by the use of a deadly weapon, namely glass, by cutting her. And in the manner of its use and intended use, glass shards are capable of causing serious bodily injury. And that you cut her, a member of your family, with the glass. Signed, your name, I swear to God, all that's true. So, are you lying today, or are you lying when you looked at me in the eye under oath and committed perjury then?
No, sir.
No, sir, what?
No,
Oh, but you admitted you did
Yes,
it
I
all
did.
under oath.
yes, sir.
Is that what you're standing by,
Sir.
sir?
Yes, sir.
Sounded differently a few minutes ago. You weren't guilty of it. Let's stay next.
Judge, I don't feel that probation is warranted, number one, because he doesn't truly accept responsibility for his actions. Number two, we've basically been trying to make the complainant out to be the bad person. And the court is focused a lot on that, and I appreciate that. I want to highlight the fact that his child was present at this occasion as well. 7 years old. She was listed as one of the witnesses as well. And apparently, when looking through his history of the 6 different domestic matters that he was arrested on, apparently a child was present at one in 2019. So I disagree with his lawyer. I feel that his conduct is consistent. He chooses to drink on a daily basis. He makes bad choices. Obviously, when he's drunk, that's apparent from the 2 pages worth of criminal history that we have here. He's not eligible for probation from a jury. That's why Mr. Lane convinced my trial partner to allow him to cap this agreement to make the pitch that he did today. If he, however, had maybe had some different statements to your probation officer, he might have been off on a stronger foot. But the reality is he doesn't accept responsibility. His kids have already seen too much of this. His wife at that time is nothing more than the victim, and certainly not the scapegoat in this matter. The state was at a point when this case was on the trial docket suggesting 10 years. It was only through good lawyering by Mr. Lane that we conceded and did this cap agreement here. I agree with Mr. Laird, and what's appropriate here is 7 years.
All right. Rebuttal, anything else?
Well, Your Honor, we disagree with that. We think that the conditions of probation will provide the protection for.
But he's failed in probation before.
Your Honor, if the court is inclined to place him in prison, he did 1 year, actually 10.5 months on this previous deal. We would ask the court to go closer to the minimum condition. He doesn't care. That is going to provide, well, the deterrence that the system requires. And
how about protection in the community and in the home from this man's repeated disturbing behavior of violence and in constant intoxication?
I understand. And Mr. Jason would like to address the court.
Yeah. What else would you like to say?
I mean, if probation, I even mess up and also always manage.
You made a promise when you were placed on probation the last time. That you made a promise to the court and you failed that, right? All courts make have the same set of documents essentially, and you make a promise. I swear I will follow all the terms and I know I can be revoked, and that's what happened.
Do anything I have to do.
You know what you need to do is live in peace with the people you quote, that you state and purport to say that you love and care for. I can't imagine anyone, much less someone I care for and profess love as a spouse like mine or yours, that you would quite naturally be in a constant state of intoxication as a role model, which is poor. But number next, you threaten to cut somebody with shards of glass. I mean, that's a twilight zone of a life. That doesn't have anything close to love and honor and commitment and loyalty. You betrayed those vows. You betrayed the laws. You defied the laws, and you committed a crime. And it's a violent crime. And it begs the question: if you would do this for someone you love, you say you love, if you do this to them, what would you do to somebody who you decided you needed to harm, who you had no association with? It's frightening thought. You have pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There's sufficient evidence supporting a guilty plea. State's Exhibit 1 admitted here in the plea hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. There will be an affirmative finding on the judgment rendered that a deadly weapon, mainly glass, was used in the commission of this offense, and that will be rendered on the judgment. Anything else? That is all. Next is Kiona Ozane.
Mr. Adams is unavailable.
Next is